If I put my kid's name on my checking account and or my house, do I really need a will or power of attorney?
I still think you need to consider some estate planning. Those options are common these days, but there's some real problems with going that way. The first of which is control. When you take your house or your checking account and you put your kid's name on it, you've just made them joint owners of the property. If you decide at a later date that you want to do something different with that property, you've got to get permission from your child. So if you decide you want to sell the house and move down to sunny Florida, if your son or your daughter says they don't think that's a good idea, you're stuck. You can't really sell your house. The second reason why it's a problem is that you expose your assets to the creditors of your children. So when they become joint owners of the property, if they get into financial trouble and they have creditors that are going to come after them, they're going to come after your property now too because it's jointly owned. Even if your kid is financially responsible and you're not concerned about those issues, they can also just suffer some bad fortune. They could get sued in a lawsuit, and their assets then become something that could be attached just as if they were your assets. So that's another problem. The third problem with the joint ownership route is a tax issue, and that is capital gains. If you can imagine a situation in which you would purchase your house for $100,000, it's now worth $300,000. If you die and your kids inherit it, they take your house at the date of death value. So when they go to sell your house, it's going to be assumed that they purchased it at $300,000. If they sell it for $300,000, there's no capital gains and no tax. If you gave them the house before you died, you made them joint owners to the house, then you have a situation where they are going to take their basis as your basis. So now when they go to sell it for $300,000, they're going to be assumed to have purchased it at the same price that you did. So now they've exposed themselves to, in that situation, a couple $100,000 in capital gains. The fourth reason why joint ownership is a bad issue, is a bad idea, is that in mortgage documents, there's usually a provision that states that if the owner of the property changes, they can accelerate the mortgage. So you put your child on your house, you've got a mortgage. Legally, the bank could come to you and say, look, we want to be paid within 30 days because now you've changed the owner of the property. Obviously, that's not a good situation that you want to be in. The last reason why joint ownership can cause some problems is about the gift consequences. Giving title to your child while you're alive, either in the form of putting them on your deed or your checking account, is actually giving a gift. If the value of that is more than $13,000, you're required to file a gift tax return with the IRS. There's a secondary problem with that in that you've now given money away, and if at some point in time you need to qualify for Medicaid to pay for nursing home, they're going to look at any of those joint title situations as gifts that you made, and they're going to count that against you in your eligibility for Medicaid. For those 5 reasons, I think that joint ownership just really isn't a solution to estate planning needs.